Hello, everyone. This is Haley Hansen. I'm the leader of Husch Blackwell's Higher Education Group. We are excited today to be presenting on state and federal laws regarding pregnancy discrimination. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during today's program. I'd like to take a minute to just highlight a few of them for you. First, if you have any questions during the webinar, please submit your questions via the question box. We will try to answer your questions at the end of today's webinar, but if a fuller answer is necessary or we run out of time, which is possible, then we will send you an email with a response to your question. We truly appreciate audience participation and encourage you to submit any questions that you have. Also, there is an icon to assist you with viewing preferences. Please note that you can expand your slide area by clicking on the maximum icon on the bottom right of the slide area or by dragging the bottom right corner of the slide area to make it bigger. If you have technical difficulties, please go to the help icon. It has a question mark and can provide you some common answers to technical issues. Also, a copy of today's webinar slide deck, and we actually included additional materials as well, is available for you in the resource list icon. So if you'd like the materials or would like to print them off, you can do that through the resource list, and we've included additional materials that Katie, Joe, and I are going to be talking about during today's webinar as well. This program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. To report your hours in Illinois, Kansas, Nebraska, Tennessee, or Texas, click on the CLE icon at the bottom of your screen and complete the questions. You will also need to submit your bar number at the bottom. A recording of this webinar will be available for watching and sharing tomorrow, likely. When the link is sent out, you will also receive a certificate of attendance. All right, now that we're to the housekeeping matters, let me introduce Katie Jo Lunningham, who's also going to be speaking today. Katie Jo focuses her practice on serving higher education institutions and providing outside general counsel services, compliance services, and auditing, investigation, and works a lot in our litigation group as well. She works for a variety of public and private colleges and universities. So we welcome Katie Jo. So with that, let's go ahead and get started with the webinar. We are going to focus today, just to make sure everyone's on the same page, we're going to focus on background of accommodating pregnant and parenting students. And then Katie Jo is going to take us through the case law, administrative enforcement, and some of the current events in this area. And then at the end, I'm going to walk you through developing policies and procedures for compliance, what that looks like, what best practices are, and what you maybe want to consider, as it's a good time to change your policies during the summer months when you don't have as many students on your campuses. So as we talk about background, let's go ahead and discuss pregnancy discrimination. Obviously, it's a form of sex discrimination because only women can become pregnant, and it's explicitly included within regulations, including Title IX, and that's one of the regulations that we're really going to be focusing on today. So the main overarching principle that is on this slide that I think is very important is that institutions can't unilaterally presume limitations of a pregnant student. And so as we talk about a lot of these cases, as we talk about how to handle issues that happen at your institution, remember that we cannot substitute our judgment for the student's judgment and must make sure that we are providing the student their options of what they want to do in terms of continuing on with their education. So I think that's a guiding principle as we go through today's webinar. So with that, I'm going to ask the first poll question. What kind of pregnancy discrimination policy do you have at your institution? We've seen some institutions that have a separate written pregnancy discrimination policy and pregnancy disclosure policy. Other institutions we have seen include that or embed it into their broader discrimination policies, but there's not There's no specificity just for pregnancy. They have it in their broader policies. And then finally, some institutions don't really address it at all. So hopefully not a lot of us are falling into that third category. But if you go ahead and enter your response to the poll question, that would be great. Okay. So for the 7.5% of you that say none right now, we'll talk to you at the end of the presentation about what you should be putting in your policies and procedures. The majority of you are falling into that category where it's embedded into other discrimination procedures. And again, we've seen that pretty consistently when it comes to addressing discrimination and how complaints of discrimination will be handled, those types of things. That makes a lot of sense. Having a written pregnancy policy, not necessarily a discrimination policy, but a pregnancy policy upon which you identify who you can disclose to and options, those types of things we think is important as well. So again, what we're really seeing is a best practice. It's typically embedded, but we do have situations in which a separate policy is necessary for identifying, having students know where they can go to identify that they're pregnant and talk through their options as they go through their pregnancy. So let's just take a very high-level look at what the federal laws are that are applicable to pregnant students. Number one, obviously, Title IX. We know that pregnancy is specifically talked about in the regulations. I'm going to talk a little bit more about the Dear Colleague letter that we have all been working through and that is still in force and effect as of 11 o'clock when I checked this morning. You don't know when Dear Colleague letters may be withdrawn by the Trump administration, but as of today had not been withdrawn. So that Dear Colleague letter is still in effect. We also have for employment, we have Title VII and the Pregnancy Discrimination Act. The Family Medical Leave Act, again, more of an employment when somebody has worked for the employer for more than 1,250 hours during that year. So you may have some students that are also employees that fall into that category, but it's not going to be the majority of your student workers because most of your student workers don't work that much during the school year. Then talking about the Affordable Care Act and the FLSA, obviously, it can have implications as well. And then we're going to talk a lot about the Americans with Disabilities Act, and similarly, we probably should have included this for private institutions, Section 504. And when we talk about Section 504, it mirrors the ADA when it comes to student accommodations, but we're going to spend a lot of time, and Katie Jo is going to talk about some of the lawsuits we've seen in those areas as well. And it's also important to know we have a lot of people on our webinar today, which is great that you cover a lot of different states, as you probably guessed from listening to all the places in which we got CLE credit approved. And so therefore you may have a state law that you want to make sure you're complying with as well. So pregnancy discrimination in Title IX, obviously it's prohibited with respect to all aspects of from admissions to hiring, if it's employment, to leave policies, courtroom accommodations. All of those are covered within the umbrella. And I think it's important to understand, too, that some of these cases start with good intentions of faculty. So we've seen for faculty members who are doing interviews for graduate programs or accelerated programs, a student or prospective student may disclose that they are pregnant. They were not asked, so that's good that they were not asked, but they may disclose it, and then the faculty member will try to dissuade them from entering the program or say, this isn't the right time for you, those types of things, and then they don't get into the program, which then has led to pregnancy discrimination claims either through the Office for Civil Rights or through lawsuits. So be very careful, and as you're doing your back-to-school training, talk about this issue, that it is not up to the judgment of the faculty to dissuade a pregnant student, a pregnant woman, whether they believe they can meet the requirements of the program. If they are, you obviously have set forth the academic requirements, and under Title IX they can discuss what types of coursework or other accommodations, temporary accommodations may be necessary, but dissuading them can be an issue as well. All right, so the Department of Education guidance. When we talk about the Office for Civil Rights, it released on June 25th, 2013, its Dear Colleague letter that was geared towards K-12, but also include that wonderful language in Dear Colleague letters, which we all at Higher Ed love to see. All aspects of this Dear Colleague letter also apply to higher education institutions. And so essentially, and that's been, again, interpreted as applying to all higher education institutions through OCR policy or through investigation, that yes, this does apply to higher ed and you need to make sure you're complying with it. So the Department of Education guidance obviously talks about several different things, but it really talks about making sure, number one, that students are provided their options and that adjustments are provided just as any other type of temporary service or adjustment would be provided to other students that have some sort of medical issue or other temporary issue that need to be addressed. It also really the guidance talks about that the student has to be reinstated at the same status she was when she left to have the baby or left as due to pregnancy-related complications. So you must reinstate. So a lot of schools have different requirements if someone's coming back from a leave of absence. So you need to make sure you're looking at those, and are they appropriate or could they be interpreted to be discriminatory to pregnant students as their leave for the birth of their baby or other pregnancy-related leave. When absences are medically necessary, they must be excused. So you must treat them as an excused absence and work with the student to make up the coursework or the clinical setting if you're in nursing or whatever they have missed. And you should be making exceptions for late work or classroom attendance or even participation credit for those who, again, are not able to attend. Going back to that medically necessary leave, a question that I get a lot is, can we request documentation? And the answer is yes, you can request documentation for the medically necessary leave. One distinction, though, that I want to point out, and I think is very important, and when we talk about pregnancy, I get this question a lot as well, is whether or not you can require a release to return to school after giving birth. And the answer that the Department of Education has given through its guidance has said that only if you have a policy requiring anyone who is gone and under the care for either a physical issue or a mental issue, that you require that they also provide that release to return to the program. So you can't just single out pregnant students and say, well, we know you just gave birth because we, maybe saw that you were pregnant or you disclosed it to us and you were gone for this period of time, so we're going to only require those students that are pregnant to provide that documentation. Because there's lots of times that students are under a physician's care for other health concerns and have to take a leave. Due to that, you'd need to require that they provide the same type of documentation, and that includes not only physical but mental issues that students are facing as well. So why does compliance matter? Obviously, compliance matters for a whole host of reasons. The first being compliance with the Office for Civil Rights. Katie Jo is going to talk about the increased number of complaints made to the Office for Civil Rights based on pregnancy and specifically under Title IX. And we're also seeing lawsuits, and Katie Jo is going to talk about that in detail, how many lawsuits are being filed as well. So what is the key language when we talk about what the Department of Education in the regulations requires? And again, it ties back to your federal financial aid. So any recipients of federal funds shall not apply any rule concerning a student's actual or potential parental, family, or marital status, which treats students differently on the basis of sex. So again, treating somebody differently on the basis of sex, which would then exclude them from participation in a program or activity or even extracurricular activities on the basis of that pregnancy, childbirth, false pregnancy, or even termination of a pregnancy and their the student's recovery from that. So admissions decisions, I talked a lot about this as well, but again, you can't apply a rule which treats somebody differently based on their sex or discriminate based on their sex. You've got to make sure that your rules apply to everyone and that you're treating the pregnant students the same way that you would treat anyone else with a temporary disability or physical condition. The rules talk a lot about employment as well. This webinar is really focused on students, but students can be employees as well, so it's important to just remind you that you can't discriminate against any employee or applicant for employment based on their pregnancy status and the leave that they may or may not be taking. So what the most common, I guess, example that I can give you is of that is somebody that is hiring for a position that they think is going to need a lot of attention, and the person either discloses or they are aware because they're transferring, within the school from a different department that the person is pregnant, so therefore they're not including them or don't think they're a good fit because they know they're going to be on FMLA leave or know they're going to take some sort of leave. Obviously, that's prohibited when we look at the law and making sure that pregnant students and employees are protected. So financial aid assistance, there's no category for pregnant students, but there is categories for parenting students when you have your child more than 50% of the time that you can apply for and receive a different types of financial aid. And so it's important that pregnant students understand that and that they are able to ask questions directly to the financial aid office. It's been a huge area of contention, and one that I just will point out to you is when you have a student that takes a leave and wants to come back, and again, the Department of Education says they should begin where they left, and schools are requiring them to retake courses if they left in the middle of the course, and they're charging them twice for the courses as well. So that can be very problematic and is something that pregnant students are raising not only with the Office for Civil Rights but also in litigation as discriminatory, that they are being charged twice due to their pregnancy status for the same courses. So looking at that as well, I think is very important when you look at all the aspects of your policy that you want to make sure are buttoned up with regard to pregnant students. So we talked about this a little bit, but the leave of absence is always, when I do back to school training, seems to be a large sticking point for a lot of faculty. So they really want to understand that. And that is, again, as long as the leave is deemed medically necessary, then you need to work with the student to figure out how you can provide that education, that content. It doesn't have to be in the exact same manner that they would have received it had they been at class or clinical or internship, but you've got to figure out how you can do that. Now, we go back to, there's not a whole bunch of guidance on this, but we go back to more of a reasonableness standard in this area as well as to how long do you have to show this, and I go back to how long does the physician say that it's medically necessary, and there's a difference between medically necessary and a student making a determination that they need more time because they are, physically doing all right, but they want to care for their child, or there's other issues that have come into their life. So I think that's important as well as you're looking at leave of absence and the medical documentation. So as I'm talking about all these things, you can kind of see the need for a centralized location on your campus as to where you're sending pregnant students, and making sure that you have a policy addressing how they could self-identify. We're never going to ask pregnant students if they're pregnant, but obviously that would be a legal issue for you if you did so do not do that. But you want to have this centralized location so all of these things can be considered and a place in which you have that medical documentation. Where we've seen the biggest issues is when faculty decide that they're going to do it themselves. And so faculty are going to independently determine what's appropriate, independently maybe ask for documentation or not ask for documentation, and it's not consistent and gets schools into pretty big issues that Katie Jo is going to talk about in detail, pretty big legal issues. So here's the direct quote about coursework accommodations from the Department of Education. Again, places the burden on schools to accommodate students, going so far as to say that they should advise pregnant students of the importance in staying in school and let them know of any assistance that may be available. So why is this important? This is very important for several reasons, but the number one reason is because when a pregnant student may disclose to a faculty member that they're pregnant, but nothing's going to change. They anticipate giving birth on Friday afternoon and being back in school on Monday. And so there's going to be no change from the birth of this baby, and they don't want any assistance or accommodation. The Department of Education is placing the burden on schools to let students know what their options are. Some of the things that we just talked about. Are there changes with financial aid? What are their options in terms of, the three main options, staying in school and having a medical excuse and returning and making up those classes or that coursework. The second option is what your leave policies are, or maybe incomplete policies, and what that looks like and how that may be available to them. And then the third option is withdrawing from school. And we want to try to hopefully discourage students from doing that, but those are their options. And so making sure that is, again, the burden on the school to say that schools should advise students of their options and try to work through those options instead of the faculty member hearing this news and saying, well, that's great, and not doing anything with it. Now, again, they're not asking for any accommodations, but it's important that we follow through on our obligations and that at least the person that you put in charge of working with pregnant students at your school has knowledge that this person is pregnant, because the school knows it now, the faculty knows it, and so they would need to have knowledge that this person is pregnant, because from a mom of two, I can tell you things didn't go quite the way that I thought they were going to go at the outset of my pregnancies with my children, and that happens very frequently. That is something that you really can't plan when a baby is going to want to be born or decide that it's going to be born, and so those are things that we need to consider as well. All good intentions. Even I've even had the mother of four that said they've done this now three times before, so they're sure that this is when this is going to all happen, and the baby has much different ideas. So I did want to just talk briefly about pregnant student athletes. There is significant guidance from OCR and NCA about this topic, and specifically on that the institution has to treat the student athlete the same way they treat anyone with an injury or an illness. They cannot withdraw the financial aid due to pregnancy, suspected pregnancy or parenthood, or even pregnancy termination. So that's important to understand as well, and that a pregnant student athlete must be returned to the same status in which she held before the leave began. So that's important as well. So with that, I will turn it over to Katie Jo to talk about our case law, administrative enforcement, and some of the current events in this space.
Thanks, Haley. So we'll kind of look first at the case law surrounding this issue, typically in the Title IX context, although certainly claims have been raised under the ADA, also under Section 504 of the Rehabilitation Act, and we will talk about that a little bit as well. We'll then kind of touch on some recent OCR enforcement resolutions that give us some guidance in this area, and then we'll conclude with talking a little bit about what I have dubbed, for lack of a better phrase, current events. This is certainly an issue that has been in the public sphere, been more high profile in the last couple of years with conversations about accommodating pregnant and parenting students, in particular women, female researchers in the STEM areas. So we'll kind of just do a little bit of an overview at the end of those kind of current events, hot topics in this area. So we'll start with this case, Darian. It's from 1997, but it does kind of set the stage for some of the more recent cases that we'll discuss. So in this case, a nursing student brought a claim alleging pregnancy discrimination. So in this instance, the university actually modified the clinical rotation portion of her nursing courses to accommodate her pregnancy complications. And then the university later decided that given the purpose of the rotation itself, that the accommodations weren't working. The university ultimately refused to provide further modifications to the clinical rotation, and the student asked to be withdrawn from the course but was denied. So she essentially checked out of the course. She did not participate in the remainder of the course and didn't take her final exam. The court, in addressing this case, held that the university had met its obligation to offer reasonable accommodations because the court reasoned it was not enough in this case that the plaintiff had a high GPA. The crucial requirement of the nursing program was to provide care to patients and to fulfill the clinical objectives. So here, when the student in the middle of the semester failed to meet the educational expectations of her coursework, the university had already done what was necessary to provide those reasonable accommodations. So in this case, the court did grant summary judgment both on the ADA claim and on the Title IX claim. So moving on to a more recent case, this case is from 2008, District Court in Washington. This student communicated with her professor. So here's a good example of communication or lack thereof with a professor leading to litigation. The student in this class communicated that she was going to miss this exam that was required as a prerequisite and participation in this group project due to the mandated bed rest and pregnancy complications. The professor refused the student's request, although ultimately made accommodations for other students with respect to this exam. And actually, unbeknownst to the professor, the student continued to work on the group project. She worked on coursework with the help of her classmates and kind of kept going within the course. When the professor did refuse her request and essentially told her to drop out of the course because her pregnancy and absences were creating a burden for the other students, this student brought suit against the university. The university moved for summary judgment, arguing that the student in this case could not show that she had met the educational requirements of this course. However, the court looked at all of the things that the student had done. She was at class until she was placed on mandated bed rest. She continued to participate in the group project. She continued to work on coursework. And in this situation, the professor had refused the accommodations while making accommodations for other students, and she had suffered that adverse treatment. Moving on to Conley, this is an even more recent case from 2015. A pregnant paramedic student was placed on release status by the EMS company that was overseeing her clinical rotation. She was placed on the status due to pregnancy complications and was not allowed to continue within this clinical rotation. The college, after this happened, refused to reinstate her, and did. The dean of the college, kind of in the case, the court includes this in the factual background. The dean of the college had at one point informed the student that they would never have admitted her to the program if they had known that she was pregnant. Not surprisingly, she brought suit against the university alleging discrimination under Title IX. Now, the university's argument in this case was sort of interesting because they just argued that there wasn't a private right of action for pregnancy discrimination under Title IX, an argument that hadn't been made in a while because people didn't really think that there was a dispute about whether one could bring an action under Title IX. So the court somewhat predictably disagreed with the college and said that although Title IX doesn't define the term sex, it's clear that Congress intended on the basis of sex to include pregnancy-based discrimination. So upholding this private right of action under Title IX, specifically in the pregnancy discrimination case law.
And again, Katie Jo, as I was talking about earlier, I mean, these are the facts that tend to lead to a lot of these claims, is that somebody saying, we wouldn't have let you in, we would, or trying to convince someone that they need to leave the program or that they're not going to be successful, and saying, well, in my experience, I know you won't be successful. You don't know. That's the issue, is that you don't know that this person may be very successful. And that's why it's important to have a process upon which you're identifying what is going to be the plan for this particular student, and then if they're not successful, treating them academically like other students would be treated, as long as you followed that accommodation plan and not trying to dissuade them either from the outset or, I cringe when I hear the comment that the dean said of, we would never have let you in, because it's not the first time I've heard that. It really isn't.
Absolutely. And I think that another key point that the Conley case, and we'll talk about it a little bit in this Barlisi case, brings up, is that some of these rotations or internships, situations where you're placing students outside of the university but are making this internship or this clinical rotation part of the course and part of their program performance, you are still on the hook for what happens in that situation. So in this Barlisi case, the student brought a case against the university. She brought it against the university and against the rehabilitation center that she had her internship at. She alleged that she was dismissed from the Master's in Social Work program because of her pregnancy and her status as an unwed pregnant woman. She essentially said that when she was at this internship, the person who was supervising her at the internship took issue with the fact that she was an unwed pregnant woman and gave her a poor performance evaluation and review at this internship, which of course called into question the university's defense, saying that she had poorly performed at this internship and that's why she was dismissed, not because of her pregnancy. So here there was some question as to whether the university had really interfered or run interference or advocated on behalf of its student in a situation where she was telling the university that she was being discriminated against in an internship setting that she was required to participate in. So in this case, the jury awarded her $850,000 and also awarded attorney's fees. The university did appeal this case. Some interesting things that happened. The university actually moved for judgment as a matter of law. They asked for a new trial, and they asked for a remitter of damages. But the court here, in particular, noted that the award didn't shock the conscience, the kind of standard in order to require remitter, because the discrimination and retaliation had deprived her of the opportunity for the employment in her chosen career. So notably in this case, the court actually granted summary judgment for the rehab facility. So the actual instance of kind of the initial discrimination, this internship supervisor, the court granted summary judgment for that facility because it wasn't an educational institution, so it wasn't subject to Title IX compliance. The court, of course, denied summary judgment for the university, and instead, at the trial court, had found that she had made a prima facie case. And so the Sixth Circuit, in affirming the district court's ruling, affirmed those determinations and also the jury award. So certainly an example of where the cost of compliance is really going to be very significant.
And I've talked about this case for, several times, and some people may have heard about it in different trainings as well, but it was good to see what the Sixth Circuit was going to do in affirming this decision. I think it's important when you look at this case, too, to understand that, we are held responsible as institutions for any program or activity. So at this, the supervisor had no employment relationship whatsoever that was allegedly discriminatory, but, the school is still held liable. And when you talk to different groups, they're surprised by that determination by the court.
Yeah, and I think it is surprising when you first hear it, but once you've heard it, I mean, you know that this is something that the court's going to look at. So the courts have made clear, and universities are at this point on notice, that you're responsible for those situations that you're placing students in as part of their program. Pregnancy is a disability. So we'll cover this in the next couple of slides, but we'll also kind of make a plug here for our most recent blog post where we did a really kind of in-depth analysis of this case. So there were two decisions in this case. The first one kind of analyzing just a general motion to dismiss, and then the second one that we'll talk about on the next slide. But to the extent that you have more questions about this, we would refer you to the blog post where you can really read more about the facts of this case. So here, a student became pregnant 3.5 years into the medical program. She suffered various physical complications, fatigue, nausea, gestational diabetes, and she also suffered from clinical depression and anxiety disorder. She provided the university with a doctor's note saying that she wasn't going to be able to fulfill her academic responsibilities, and the university actually obliged and provided many of the accommodations that she requested. She did take a 2-week leave of absence in the middle of the semester and then returned to her coursework. However, based on one class that she was taking, Ms. Khan in this case said that upon being late to her final exam, she was experiencing nausea, lightheadedness, anxiety, and requested to postpone the final exam. That request was denied by the professor. She failed the exam, she failed the course, and she was kicked out of the program. She then filed suit under Section 504 of the Rehabilitation Act alleging disability discrimination. Interestingly, she did have sort of a Title IX claim, but didn't really plead that. She focused more on the disability discrimination. And the district court in this case rejected the university's argument that Ms. Khan didn't have a disability, noting that the effects of her pregnancy, so the effects of an impairment, lasting or expecting to last fewer than 6 months, can be substantially limiting. They pulled this language from ADA and Title VII case law interpreting disability definition and the application of that to disability discrimination claims. So this decision in particular that's referenced here, you'll see, came out in December of 2015. In December of 2016, the district court actually dismissed the case outright on summary judgment because the student could not prove she was otherwise qualified. She had failed multiple classes, had previously been placed on academic probation, and the university relied on her inability to meet the otherwise qualified status as part of the disability claim. Notably, although the court ultimately dismissed this case on summary judgment, they did not back away from the disability analysis. Ms. Khan appealed this to the Seventh Circuit, and that appeal is pending. It's certainly a new wrinkle in kind of our analysis of accommodating pregnant and parenting students. We now have this case law out there, really analyzing and agreeing with a claim solely under Section 504 that has, nothing to do with what I would say would be most typical, these Title IX claims that we've seen for pregnancy discrimination. So this is very recent and it's very interesting, and we'll certainly be keeping an eye on what the Seventh Circuit does with this case.
And I mean, it's important to note, again, this is very interesting, but it's something to keep an eye on. It doesn't necessarily, if you're not in the Northern District of Illinois, it's not necessarily your law or how your law would be interpreted, as a lot of the lawyers know on the phone. But those non-lawyers that are on this webinar, I just wanted to make sure that was clear as well. And we don't know what the Seventh Circuit will do, but if pregnancy could be determined as a disability, that's going to be very different as we look at this analysis in case law. We've been really focusing on our quote-unquote temporary services that we would provide students under Title IX, and not doing a full-fledged analysis of whether they were a disabled person.
Okay, and we'll move now to kind of enforcement issues. So as we've talked about, the Office for Civil Rights would investigate complaints of Title IX noncompliance. We've seen a lot of increases mentioning pregnant and parenting students, issues and complaints. I do think that it's important to note that while there's uncertainty about this administration's ability or willingness to enforce Department of Education previous guidance that has come out, when we're talking about pregnant and parenting students, we're not really jumping into the same, I would say, politically charged arenas that there's been a lot of talk about. So withdrawing the department's Dear Colleague letter on transgender accommodations or talks about changing sexual misconduct guidance, we're not seeing that in the area of pregnant and parenting students. And we do have case law and we have former enforcement actions within this area that I think we should just kind of keep note that although certainly enforcement is up in the air right now, pregnant and parenting students and enforcement of their rights under Title IX is something that is more likely to stay really within this more traditional Title IX arena. And certainly we've seen successful lawsuits and may continue to see enforcement in this area in particular because it doesn't carry with it the same kind of politically charged background that other areas might. So here just a little bit about the numbers of complaints. So between 2009 and 2012, we saw that there were complaints addressing pregnancy or parenting-related discrimination 59 times. And in the past 3 years that we have statistics for it, that number has more than doubled. So it's certainly something that's on the rise. And just a little side note, that is also something we're seeing an increase in with respect to employees alleging pregnancy discrimination. So although this is focused on students, that's certainly another trend we're seeing in other areas. Just a brief overview of some recent OCR cases resolutions. In particular, this VMI complaint that was settled. I'd like to, at this point, talk a little bit about the NACUA note that we've placed in your resources tab. So that's an article that Haley and I co-authored with another higher education practitioner. And it provides some really great best practices and does kind of delve into the principles that we were able to pull out of this VMI complaint. So the complaint from 2014, that was settled in 2014 was a complaint that was made against VMI regarding its policy that prohibited cadet parenthood. It required cadets who married or became parents to resign voluntarily or to be deemed ineligible to enroll at the institution. This kind of evidenced OCR's intent to investigate and remedy instances of pregnancy discrimination on college campuses because OCR determined that it was in direct violation of Title IX because the policy essentially rendered pregnant female cadets ineligible to participate in the program entirely. And we also see 2 other instances in the last couple of years where OCR has taken a sort of aggressive approach in enforcing their guidance within pregnancy discrimination issues. So like I said, for more information on that, you can go to our note that's in the resources section of this presentation. And now we'll get into what will be our final poll. We'll do a little bit of a case study just to set this out. So a scenario in which Josh, so a male student, is a graduate student in the English department. So he teaches an upper-level seminar through his graduate student work and also works in the university's writing center editing papers. His wife is pregnant with their second child, and that child is due in the last month of classes right before finals. Their other child was born premature and has regular doctor's appointments that already pose scheduling issues with Josh's employment at the writing center and also with his class teaching schedule. So we'll move on to the poll questions. Think about the questions: what legal duty does the university have to accommodate Josh? And then we'll follow up on some of the ways that the university can best accommodate him. So of these 3 options, which describes the university's legal duty to accommodate Josh? The university has a legal duty and must do so. The university can accommodate him but is not legally required to. Or I have no idea. Hopefully you can make at least some educated guess on this.
Actually, one of our comments in the questions was that there should be a slot for I have no idea. So we're accommodating.
There we go.
Yeah. Sometimes that is the answer. I just have no idea.
Certainly. Okay, so we will go ahead and look at some of the results. So we've got really kind of a pretty close tie between the university must and the university can. So here is the actual Department of Education guidance, which states that institutions should consider developing policies that allow pregnant and parenting students to take leave or make up hours for parenting students, both male and female, who need to take their children to doctor's appointments or take care of sick children. So in this instance, when we're talking about how best to accommodate Josh, we want to think about how we could accommodate a female who's in the same situation. One of the things that is nice about the educational setting is that you have some flexibility. So in situations like this, you could possibly, with respect to his teaching, find a seminar slot that's either an evening class or a once-a-week class that would be easier for him to schedule around, less likely for him to miss or need someone to cover. With respect to final exams, he could do a paper instead of a particular final exam time, or conversely could do one specific final exam time that would be a little bit easier to kind of plan around. With respect to the writing center, he could work remotely in the way that some female employees have done. He could be essentially an online editor and look at online submissions. So when you're thinking about accommodating male students and what the university can do, we want to think about it in the same way that we would accommodate a female who's in the same position.
And I think that's very important, but I also want to say that the guidance does say should, and so it's going to be an institutional decision in terms of what your policy is going to be. Where I've seen schools go awry is that, again, and I hate to harp on it, but go back to this faculty making their own independent determination, and some faculty wanting to do, because they think it's the right thing to accommodate the parenting student that has a sick child or the father, and others not doing that and having inconsistency. So if you're going to have a policy, have a policy. If you're not going to do it, then we need to make sure, again, OCR recommends and says you should do it. It doesn't require it. But if you are not going to have a policy or address this, then talk to your faculty about what that looks like, that we're addressing pregnancy and the related leave that comes with pregnancy, or childbirth and pregnancy, and we're not going to talk about parenting students. So then Josh wouldn't be accommodated if they don't have that type of policy. Again, OCR during its guidance encourages you to do that. Some institutions are not there yet, or that's not the position that they want to take, and that's okay.
Now we'll move on to something that has also been talked about a lot in the public sphere in the last couple of months, the last couple of years, and that's lactation spaces. Department of Education's guidance does encourage schools to provide a designated lactation space for young mothers. This is also something that's required for your employees under the Affordable Care Act. And part of the reason that this has been so prevalent in recent months is because there have been a lot of efforts to increase awareness. There's been a lot of advocacy on this area, and there have been lots of recent news articles talking about lactation spaces, in particular how that relates to women in academia, women in research, and women in areas, in particular STEM, that are considered to be less friendly to female researchers. So this is an article that went viral talking about how the lack of family-friendly policies, specifically mentioning lactation spaces and the lack of lactation spaces as one of the primary reasons that women in STEM fields decide to abandon research careers. So I think this is something that is relevant not only for compliance, but is relevant from an institutional standpoint, because it's something that can help you really attract and retain great talent in students, in graduate students, and postdoctoral fellows, and in faculty. So it's kind of one of those concrete examples of how the university can boost its efforts to comply with, pregnancy accommodations that can also lead to kind of these benefits for attracting and retaining talent.
And I will just add my 2 cents in on this space as well, that, understanding, and I know we're going to get to this, but, how many lactation spaces you have and understanding what is an acceptable lactation space is important too. An acceptable lactation space has to have, typically electricity. It's not a handicapped restroom stall in the restroom, in the women's restroom. That's not considered to be a lactation space. And I think a lot of schools will just identify women's restrooms as lactation spaces, and they are not. And I would encourage a lock on that door for that woman as well.
Absolutely. And in the Affordable Care Act regulations, it does specifically say that it's a place other than a bathroom. So this is kind of one of those scenarios where if you're abiding by that standard, and it's also something that can be used for pregnant or parenting students, you would certainly be okay. So now our actual last poll question, which is how many designated lactation spaces does your institution have on campus? This will just give us a little bit of an idea of where our audience is at, but we do have a variety of schools with varying campus sizes, different locations, different needs, different student populations. So I think this poll is always interesting to see where other institutions are at and what your institution looks like.
And one of the questions that came in, while we'll let a few people answer this, is, do you have to have a refrigeration available? And the guidance is not that specific in terms of requiring to have a refrigerator. And in fact, you can get the ice packs and things to store milk. But that is not as specific. Obviously, if you're looking at this as being family friendly, those types of things increase the family friendliness. And I do think it's important to understand that the family restroom is not a lactation space because it is, in fact, a restroom. And so even though people will say, well, it's separate and has a lock on the door, still under the Affordable Care Act guidelines, that doesn't really qualify under those guidelines. So.
Yeah. And there have been some articles talking about how many really an institution of a certain size should have. I think it's also important to note that it's not just the number, but also the location. And that certainly could impact if you are a campus that is largely pedestrian, you have a very large footprint. You may have multiple lactation stations or lactation spaces, but if it takes a long time to walk to those, are they really in places that are accessible? Is that really an accommodation that is helpful for pregnant and parenting students or for employees? Again, if you're up north and have bad winters, or you're down south and it's really hot, are they having to walk half a mile to the nearest lactation space? And what sort of accommodation is that really for students? So some general takeaways from the case law enforcement and kind of current articles that we've addressed is be creative, but also be consistent. There are a variety of options that a university has to accommodate pregnant and parenting students, and there's tremendous flexibility within the university and within the academic school year and how you can plan those, but you also need to be consistent. You need to be applying your policies and procedures in a consistent manner to the extent that you have them. And like Haley noted and like we've discussed, if you don't have a policy, it is what it is, but you need to be making sure that everything is consistent across the board. So with that, I will turn it over to Haley.
Well, we have 6 minutes to tell you how to create your new policies if you don't have them from the beginning. So I'll go through this fairly quickly. We've gotten a ton of questions, which is great. We will make sure that, because we're going to likely run out of time, that we give you a written response to all your questions. But there were lots on this lactation question as well. And the Affordable Care Act talks about employees and not students. So I don't want to make that line blurry. It is talking about employees. But the issue that I think a lot of employers have, and also employers like colleges and universities with students, is that typically when you have a nursing mother, they have to pump at a similar time because, for all of those who can identify with what I'm going to say, as a mother a while ago in those shoes, you feed your child before you leave for work, and then there's a certain amount of time in which then that would be necessary to go to the lactation space. And so not only looking at the numbers, but what you're going to do if you have multiple people that are trying to use the space at the same time is also important as well. So again, I was trying to answer some of those questions that came in as we were talking about lactation spaces. So policies and procedures at your institution, switching gears just a little bit. Again, we want you to be on the offensive, not the defensive, and not to have, as Katie Jo was talking about, really very inconsistent and not really knowing what your faculty, what your other employees or staff are saying to pregnant students. It can be a wide variety, and in fact, as we were preparing for this webinar, we were reading testimony from cases or even from trials, and we're shocked that people still say the things that they do, or at least had admitted in these cases, will still say things about pregnant women. So you've got to make sure you're on the offensive. Number one, having some sort of policy that we call a pregnancy policy in which you can identify where you can go to get questions and get help. That's going to be important. And making sure that you're training your faculty, your employees on this portion of Title IX is important as well. So as you all know, you cannot require students to identify, but you can encourage them to identify themselves as pregnant, and we call this a pregnancy disclosure policy. And if you look at the NACUA note that Katie Jo and I were co-authors on, you will see that we gave you the elements of that policy. So what should be contained in that policy. So we're not going to be doing a deep dive because it's right there for you in your materials, and we wanted to share that information as well if you don't have a pregnancy disclosure policy. It's also important that you talk about warnings, not only for pregnancy, but for other medical conditions that you may want to on a syllabus post if that particular chem lab or poses any type of threat or warning or potential issue. You may want to, you do want to go ahead and do that and identify what those dangers exist. Also, your policy needs to identify what I talked about earlier, those three options for the student who has self-identified. So continuing in their education program, what does that look like? What are they anticipating? How are we going to make up the excused absence? And again, excused absences are linked to a doctor saying that they are, a doctor or nurse saying that they are medically necessary, those absences. So how are we going to work with that student? Some of your courses build on each other, and so therefore, we may have a shortened period of time. You don't have to give the exact same experience, but you must show that they have mastery of the course outcomes, the learning objectives, those things that are addressed as you're making a determination as whether or not the student has met those requirements and what grade will be assigned. Also, that they can request a leave of absence, what your time frame is for a leave of absence, whether or not under leave of absences you have additional policies that you may be asked to waive for pregnant students and likely should be waiving if you require them to reapply. If any student that takes a leave of absence has to reapply, you may want to consider that and what questions pregnant students may raise through OCR, through litigation of how that would be looked at as discriminatory. And then finally, withdrawing from the institution. So those would be the three options. Institutional planning. Again, this is, I call it an accommodations-like process. We understand it's not an accommodations process, but we encourage you to have the students sit down with you and have an individualized assessment and create a pregnancy plan. That's what we call it for our institutions. And the student signs off on the pregnancy plan. And it may be that they right now understand their options. They don't want any accommodations or assistance, or I say accommodations, but that's so tied to Section 504 and ADA, but they may not want any help at this time, and so therefore they know where to come back to if things change. And this discourages this individual planning with faculty members so that we can be more consistent. One of the questions raised is who should do that? And, sometimes that may be someone within your Title IX office, and I've also seen it within the ADA or 504 office. I like the Title IX office a little bit better only because ADA and 504 confuses students sometimes that they are getting ongoing accommodations potentially, and that this is not temporary in nature, that, for other students that would need temporary services. But either way is fine. There's, as long as you have a policy that the students understand the process and how they can get assistance in that process. So what does this pregnancy plan or educational plan need to cover? Academics, financial aid, and other issues. A lot of people have asked questions about housing. Well, housing is the wonderful lawyer's answer that it depends. But sometimes there may be situations in which you will have to accommodate for housing, and other times possibly not. But more than likely, we've seen areas that have been trying to accommodate housing. Or housing, working with the student to come up with a plan. The best case scenario is to have an agreement with the student. Again, when you take a unilateral approach to tell them what they can or cannot do, it doesn't typically end well for the school because they're feeling like they're being pressured into doing one thing or another, or their faculty member only has their best interests at heart. I can't tell you how many times I've heard that, and is encouraging them to drop their class. Well, that may be what the academic reality is because they're failing, but they take it as, well, they're pregnant, and so therefore you're discriminating against them. So it's a very difficult situation to be in those areas. So make sure that the accommodations, as you're looking at the academic work, that you look at what type of academic work. Is it just didactic, in-class work, or is it going to be clinical rotations or lab work that would require different types of accommodations? That could be set forth in the plan as well. And look at whether or not there's other leave flexibility, whether there's technology that you can use to help the student get through, help the female student get through their program. Look at all of those issues as well. So I think that's very important. I think Katie Jo talked a little bit earlier about STEM, so I won't go over this very much, but I do want to talk, and you can chime in as well. When you talk about labs, making sure that you do have those warning signs, talk about what the accommodations are, working through those accommodations, and having some sort of written policy are really the best practices.
Yeah, this is a nice kind of bridge between the STEM discussion that we had and also that slide on warnings. So obviously very applicable here.
I agree. So again, in clinical programs, making sure that it's not just for, this is what I hear all the time for clinical rotations. Oh, we treat everyone the same. If you miss more than 2, you failed, or you got a grade lower. You can't do that for pregnant students. It is an excused absence that you have to figure out how you're going to allow them to show, again, not in the same manner that was presented to other students, but how you're going to show that they can meet the requirements of that course. And so I think that's important as well. It's also important that you identify readmission policies as well and talk about these things as you go through readmission. So we've given you a lot of information today. We're out of time. We probably could have talked about this for an hour longer today. But remember that we have our blog post available that talks in depth about the con case. We will continue to blog about pregnancy. I know that we also included other materials in the reference icon, and so make sure you're looking at those. And lots and lots of you have submitted questions, and so we promise to, within the next few days, you'll either get an email back from Katie Jo or myself answering your questions, and if we need further follow-up, if it really, unfortunately sometimes in private schools especially, and then also in public schools, the answer may depend on your policies, and so we may have to, get a little bit more information on your question based on how your policy is written, but we'll go ahead and do that. So since we don't have any time for questions, we're already out of time. Thank you so much for joining us for our program today. We hope the information was helpful. to your school. If you have not already done so, please click the survey icon at the bottom of your screen and complete a short survey. Your feedback is very helpful, specifically of what types of topics you are interested in hearing from us in the future. If this is your first webinar, we do a monthly webinar series. Many of you, this is not your first webinar, so we really are interested in what you would like to know about so we can plan future webinars as well. So with that, again, the reminder that this program has been approved for continuing legal education credit for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin. And a recording of the webinar will be available tomorrow for watching or sharing amongst your colleagues on campus that may have missed it. Once the link is available, you will also have a certificate of attendance that will be emailed to you. Please be sure to join us for our next webinar on July 25th. We're going to be doing a deep dive into query compliance, something that's near and dear to everyone's heart this time of year as we gear up for our October 1st annual security reports. So with that, this concludes our webinar. Thank you.